Yeah.
Okay. And you got the hospitals behind me?
Mm-hmm.
Okay. Turn it on. Hi, this is Mark Sokolow. I've been an attorney for over 30 years, and I've been teaching political science, and now I'm teaching business law. What we're going to go over today is a lesson plan on contracts and basic terms thereof, and we're going to study a case involving IASIS Hospital, wherein the city of Port Arthur gave them incentives to build a hospital on vacant land, and it was a state-of-the-art hospital as well as to build a medical office building. I'm going to quickly go over the contract terms. As you recall, the purpose of contracts is it should be a blueprint for success. In other words, both sides should want that the project should succeed. You want to document the deal, avoid ambiguities, make certain it's in English. You want to allocate costs for contingencies or risk or unknowns. You want to delineate procedures for disputes. Now let's look at the types of clauses that we have. Of course, the title of the agreement is just simply going to say agreement. Now, a good agreement, of course, lists the parties. The parties are the people that sign it. Say, who are these parties? What type of entities? Are they corporations? Are they municipalities? Who are they? When is the agreement effective? Sometimes you sign it this month, but it's not effective for 2 months. How long the agreement is, the duration of the agreement, the description of the goods or services that are being provided. A force majeure clause is sometimes included. That's, sometimes you have an unknown occur, a hurricane. If a hurricane or act of war occurs, what do? You have demobilization, remobilization charges. If you're delivering goods or services, where are they being delivered? What's the price for the services? Is it a set rate? Is it an hourly rate? Is it modified based on CPI? Is it a cost reimbursement contract? Is it a cost plus agreement? Is it a contingency agreement? Many legal fees are on a contingency, especially personal injury. Construction contracts are usually based on progress payments. Professional services agreements are usually based on an hourly rate. Then you go into the payment. Are you paid up front? Are you paid in progress payments, which, as I said, is for construction? Are you paid within a certain amount of time after the services are rendered? That's when a situation usually is professional services. Are you paid when the job is completed? Is it a contingency? Change orders, it's usually more of a construction. Any changes in the scope of the project or the price have to be approved by both parties. That's usually one way of saying it. Sometimes you can limit your change orders. But you have some type of procedure to deal with change in scope or change in price. Warranties, you want a clause dealing with warranties. Usually in construction, it's 1 year from the day of substantial completion. In professional services agreements, sometimes you have a limitation of liability of the contractor. For example, their liability is limited to $1 million, but you may ask that they have liability insurance. And you can ask that you be included as an additional insured. In construction, you can have a performance bond or a payment bond. These are basically insurance instruments that are given by, you'd say, by Safeco. Performance bond ensures the completion of the project. A payment bond ensures the payment of the subcontractors. Sometimes you might want an indemnity clause to hold you harmless in case of, construction activities of your contractor. You don't need all these agreements. It's really up to the experience of the lawyers who are drafting these agreements as to which clauses that you're going to need. Venue. That just tells you where, if there's going to be a lawsuit, what county it's going to be. You can be located in Harris County but do work in Jefferson County. It's negotiable where the venue is going to be. Also, if you have a dispute, you may sit there and say, I want to go to mediation first, which just is simply more of an organized settlement discussion with a facilitator. And if you are going to have a mediation clause, it's good to go ahead and set down the cost of the mediation if you know it or how they're going to be paid. You can also say if there's a dispute, I want to go to arbitration. But again, you need to decide who's going to be the arbitrator. Are you going to get a panel from the American Arbitration Association? Also, who's going to pay for this arbitration? Governing law, you can have a paragraph on governing law. If you're doing business in, you have a Louisiana company come over here, you may want to make it clear that you're going to have the agreement governed by the laws of Texas. Also, it's negotiable as to where the law is going to be that you're going to agree to. A termination clause. Both sides can agree that each side can terminate it with 30 days notice, or you can simply say we're going to terminate with cause, with 10 days notice. An entire agreement clause, all that is simply that this is the entire agreement, it supersedes any other agreement. Independent contractor, you're just simply saying that they're not your employees, that they are contractors. Assignment clause, we did a lot of this on industrial dispute agreements. It talks about the right of a party to assign an agreement and whether or not you want to consent to it. Severability clause, if any term of this agreement shall be held to be invalid, it shall not affect any other provisions of the agreement. I call it the oops clause, just in case somebody drafts a clause that just wasn't legal. It won't affect the rest of the agreement. Undocumented workers, that's just an agreement that they won't use undocumented workers. Now it's required of incentive agreements in cities in Texas to have them. Notice of default, if there's a default, there's a breach, you're just giving time for them to cure. In this case, I put down 30 days. Delay damages. This is what you see when you get into construction. How long, if they're late, what's the liquidated damages going to be? And you can, when you're doing construction contracts, you decide whether or not you want to have the time for them to complete it to be calendar days or rain days. Calendar days is straight days. Rain days, of course, if it rains, they get a delay based on it. And of course, you have signature lines. You got to sign the agreement, but be certain that you sign it on behalf of the corporation if the party is the corporation. Don't sign it in your personal capacity. On April 29, 2003, the City of Port Arthur entered into a $7,340,000 incentive agreement between IASIS, Williams & Rayo, Port Arthur, Warhorse, and the Economic Development Corporation. Basically, this was a large tract of vacant land that was adjacent to Highway 365. And we were working with IASIS, which is a Delaware corporation, for them to build an $80 million hospital in Port Arthur. And this was the incentive agreement that we negotiated, and that was successful. Based on this agreement, which was over $7 million in incentives, IASIS came in and spent over $40 million, and I think the total was for them to spend up to $80 million to build a state-of-the-art hospital. So let's go over this incentive agreement for a few minutes. Again, the title of it is Economic Incentive Agreement. And one of the things as a business that you would like to do is try to get economic incentive agreements. And this was entered, effective date was May 15, 2003. IASIS actually owned another hospital in Port Arthur, the Park Place Medical Center, and the Jefferson Hospital in Nederland, Texas. And they plan to build a new state-of-the-art hospital in Port Arthur. We're looking at a vacant tract of about 155 vacant acres. On this property, there were pipeline corridors. And the people that owned the tract of land was Warhorse Development Corporation as well as Williams & Rayo. IASIS, what they plan to do is construct a 300,000 square foot, 220 bed acute care hospital facility. Now you can find this entire agreement and read it at your leisure on Resolution 03-114 on the City of Port Arthur website. Now, under this agreement, the landowner was going to be building the building pad improvements, and the Economic Development Corporation, working with the city, was going to be doing public infrastructure. So let's get down to that part of the agreement. Now, a lot of this is just description. We're describing who the City of Port Arthur, who they are, the Economic Development Corporation, which is funded by sales tax, Williams and Rayo, a limited partnership with Dr. Williams and Dr. Rayo Kalapali, IASIS Healthcare, which is a Delaware corporation, and Warhorse Development Corporation. So we're listing out the parties, who's bound by the agreement, and what type of entities they are. And now we're getting into the obligations. The EDC was going to agree to hire a design-build firm to construct public improvements at the site. One of the things when you learn when you develop a property is that you have to build the storm sewer, detention pond, sanitary sewer, water system, everything to get ready for the building to be constructed, as well as roads. Now, the Economic Development Corporation was agreeing to build this infrastructure at $5,819,000. Now, this also further indicates that the Economic Development Corporation was going to buy another 22 acres at a cost, well, they were getting the option at a cost of $50,000 per acre. The total incentive from the Economic Development Corporation was $7,340,000. The city was waiving any permit fees and any tap fees. Now here's to go the obligations of the IASIS. Okay, what you have here is a vacant piece of land, and you have the Economic Development Corporation putting in all the infrastructure up to a certain amount. Now you're having IASIS, a hospital, agreeing to spend at least $48 million, and with a total estimate of up to $80 million to build a building, and of course to put the necessary equipment, inventory, and furniture. And this building was going to be occupied and done by June 30th, 2005. The hospital was to employ over 500 full-time equivalent employees within 120 days at the time the hospital commences operations. So for the city, what they're getting out of this is they're getting approximately an $80 million hospital, a brand new state-of-the-art hospital for the citizens of Port Arthur, as well as new jobs. So this is a win-win situation for the hospital and a win-win situation for the citizens of Port Arthur. Now, the Economic Development Corporation, as part of the deal, they were going to spend up $1,100,000 to obtain 5 frontage acres of real property so that they can use it for a business park. So you're looking at not only a hospital, but also the whole area was going to be a business park as well. Warhorse Development was going to deed to the EDC another small tract of at least 1 acre. This indicates, in terms of performance, payment, and bonds, that EDC will require its design-build firm to have performance and payment bonds. They're also stating that engineers and architects would have professional liability insurance of at least $250,000 per occurrence, and all construction contracts shall have at least a 1-year warranty. This is basically meet and confer that there's, in terms of performance, that everybody's going to meet and schedule times to work together. This is a clause that when the Economic Development Corporation hires a construction company, that they're going to have liquidated damages if they don't complete the work on time. Here's an indemnity clause. The EDC agrees to indemnify the landowner, Warhorse Development, and IASIS for damages wrongly caused by negligence or willful misconduct of the city, the EDC, or their agents. Here's the next clause is we're agreeing to everybody that they're going to keep records. This is a provision that we don't expect that they can't have discrimination, but we also say to the greatest extent feasible, contracts for work to be performed in connection with any such project is to be awarded to city residents and businesses. So when you're looking at this, you're looking at new hospital coming in, new employees being hired by IASIS, but when it comes to construction, we want them to try to hire Port Arthur residents and businesses. This is a termination clause. If it turned out that the EDC just was not able to get sales tax funds enough to do the job, that they can terminate it with 60 days notice. I said earlier, this is an entire agreement clause, and basically this is the entire agreement, and it supersedes all prior written and oral agreements. In other words, it doesn't matter what you've said before, this is the agreement. Again, we have a venue clause. The agreement should be governed by the laws of the state of Texas, and if there's any dispute, it's going to be in Jefferson County. Remember, we're dealing with a Delaware corporation here. A force majeure clause, that there's a act of God, earthquake, flood, embargo, then the time of completion shall be extended for a period equivalent to the time lost as a result thereof. A lot of times you have notice clauses, how are you going to notify people, and it says who they're going to, as for the IASIS, this is who we need to notify. As to the city, they're supposed to notify the Port Arthur Economic Development Corporation. This is as to the city or the EDC. They notify the Economic Development Corporation, the city manager, Stephen Fitzgibbons, or myself, Mark Sokolow. And you have signature clauses on the following pages where they signed it. In the next clip,